video does a quick overview of legal protections available, basically looking at protection orders that women and other people who've suffered intimate partner violence can access. So again, here are the resources for assistance if you need them, and they're also on our website. Generally, there's been a lot of study into the use of criminal law as a remedy for domestic and intimate partner violence. Historically, this type of violence has been vastly underreported. As of the ABS Personal Safety Survey, that's the Australian Bureau of Statistics Personal Safety Survey 2016, 18% of women and only 3% of men who reported in that survey that they'd been physically assaulted by a current partner had reported that to the police. In addition, in earlier surveys, such as the 2004 survey, no one had reported an intimate partner violence which involved a sexual assault to the police, even though many people reported that they had occurred. In addition to that, not all forms of domestic violence are either criminal offences or are easily provable as criminal offences, such as psychological abuse, verbal abuse, and some forms of economic abuse. These are often very hard to prove. The standard of proof in criminal cases, as you all know, is beyond a reasonable doubt. That means that where there is a contest of versions of events, and that is extraordinarily common in intimate partner violence, where one partner reports an occurrence, the other partner will often deny that it occurred. And then where there are no witnesses and no physical damage or other evidence of violence, it can be very, very difficult to prove. In addition to that, many people would claim to be either provoked or acting in self-defense, either where they've been victims of domestic violence, or perpetrators sometimes use those as claims to excuse their violence. Another problem with criminal law is that the aim is to punish a past occurrence of violence rather than to prevent future occurrences of violence. And the timeframes are very long, often taking years to finish, which may leave a victim of domestic violence in a very vulnerable position where her or his ex-partner or their ex-partner is in the community. Another option that is often used are protection orders. A family violence protection order under the Queensland Domestic and Family Violence Protection Act is a civil order that imposes conditions to protect a person from future domestic violence. Generally, they're made by the Magistrates Court, and a person can apply themselves for a protection order, or the police can apply for a protection order if they wish to protect a person who's been a victim or survivor of domestic violence. The order can cover others, such as children in the home, or other relatives who a victim may be concerned there would be threats towards. The Act does not only cover intimate personal relationships, it also covers a range of situations, including other forms of family relationships and carer relationships, where they are informal rather than commercial relationships of care. The orders can be temporary, and usually the first order will be, or final after a final hearing. They can be amended and conditions can be changed. And conditions are commonly to keep away from a person, to not be violent to a person. Where a perpetrator has firearms, they will have to give up their firearms usually. And a range of other conditions can be common. To get this type of order, you have to prove that the order is both necessary and desirable. It is not an either or, you have to prove both of them. And you can look at the case of TJ and TJF from the Queensland District Court if you're interested in finding out more about the test. This can be critiqued by some people on the basis that it effectively creates a two-tier system for dealing with violence within the family, that generally other forms of violence in the community are the subject of criminal offence proceedings, whereas domestic and family violence is treated as a private civil matter. However, on the other side, the counter-argument is that some people will not seek criminal law intervention into a family violence matter, where they may be more likely to seek assistance if they feel that their partner will not be criminalised, particularly where they're reliant on the partner's income, and or they feel that the partner may not behave in a violent way again in the future if they are under an order. Another issue with protection orders is that sometimes they actually have the unfortunate effect of emboldening some offenders. If a victim or the police do not take minor breaches of the order seriously, and if there is not an immediate response to that, then some offenders are emboldened and feel that there will be no response to more serious breaches and more serious violent events. And in fact, there have been many cases of people who were killed while a Domestic and Family Violence Protection Act allegedly protected them from a violent partner. Whether that was related to the existence of the order or not is not always clearly understood. That person may have been homicidally violent anyway. So the theory behind these civil orders, again, is to allow for protection of future matters and to make it more likely that people will seek an order. However, the approach if a perpetrator breaches an order is that there is then should be a criminal response to that. It is actually a crime to breach a family and protection order, in addition to whatever crime is done to actually breach the order. So a person who is violent and who is under an order at the time will have committed an extra offence. So that's our system of domestic and family violence protection. Have a look at the Act to see the scheme in full. As I say, there are debates about whether it is desirable to not treat violence against women as a fully criminal act, or whether it is more necessary to actually take a pragmatic approach and do what is available and what will work and be accessed by victims. So that's our protection order regime.